Okay, let's jump in. Today, we are doing a deep dive into a really unusual collection of documents. They all concern an Australian Senate inquiry.
Right, specifically the one looking into ASIC, that's the Australian Securities and Investment Commission, and how it handles investigation and enforcement.
And normally, these inquiries can be a bit dry, lots of legislative detail, policy debate, but this one has a real conflict at its core.
It really does. It's a story about parliamentary procedure versus, I guess, the moral obligation to hear from victims.
Exactly. The whole thing centers on an organization called Victims of Financial Fraud, or VOFF, and what happened when they tried to submit their evidence.
And they didn't just submit one document. They put together 36 individual submissions, a huge effort.
Which were all refused by the Senate Economics References Committee, just rejected.
And that's where the real story is.
Yeah.
For you listening, this isn't just some, bureaucratic paperwork issue.
Yeah.
It raises these massive questions about who gets a voice
And why?
and why. You have this clash between the committee, which needs to stick to its very specific job reforming the system, and the need to listen to the people who are actually hoot by that system.
So let's set the scene a little. How was this inquiry even working? We know there was some informal guidance floating around at the start.
Yeah, that's right. The sources mentioned Senator Andrew Bragg had said in an interview that submissions should ideally be short, a couple of pages.
Just to keep things moving, I suppose.
Probably.
Yeah.
An efficiency thing.
Working with government and dealing with government can be quite difficult, and the government generally doesn't make it easy for people to engage. So certainly in this case, we're looking for basic submissions of a few pages explaining what the issue is, and then we will come back in touch with the submitter if we need more information. And I think that's probably the best way for us to approach it and to make it accessible. And we want to have an inquiry which is accessible.
I mean, the goal there was clearly to show the sheer scale of the problem.
Yeah.
That it wasn't just one or two isolated incidents.
It was a statement, a demonstration of what they saw as widespread systemic failure.
And that statement, it seems, immediately ran into a brick wall.
A procedural wall, yeah. They got a letter from the committee secretary, a man named Alan Rain, very close to the submission deadline.
And this letter basically said,
It said all 36 submissions were refused. So straight. Nope. VOFF described that letter as deeply troubling, which, you can understand.
Of course. All that work, all that emotional energy, just dismissed. Without a clear reason at first.
Right. And that's the key. The why wasn't immediately obvious.
So if it wasn't just the length, 36 submissions is a lot. What was the official reason? It took a few weeks for them to get that clarification.
It did. The formal explanation came in another letter from Mr. Rain about 3 weeks later on March 27th. And this is where we have to get into the bureaucratic weeds a bit.
Okay, let's do it. What was the core procedural issue here?
The official line was that the submissions didn't address the terms of reference and that they diverge onto extraneous issues.
The classic terms of reference. So for anyone listening, the TOR, that's basically the mission statement for the inquiry, right? It's what they are legally allowed to look at.
Exactly. It's the fence around their playground. If you bring something from outside that fence, they call it an extraneous issue.
And they can't touch it.
They're not supposed to, no. The committee was basically saying, look, we're not here to solve your specific case.
We're here to fix the system that created it.
Precisely. Mr. Rain's letter was very clear. He pointed out their own website says they are, quote, not able to investigate or resolve individual disputes.
So they're not a court, they're not police, they're policy architects.
That's a great way to put it. Their only real power is to write a report for Parliament with recommendations to change laws or government policy. They can't step in and rule on an individual's fight with ASIC. Their hands are tied.
Which, from a process point of view, makes sense. You have to control the scope of these things. But, and this is a really important detail, the committee didn't just say no and walk away.
No, they didn't. They offered a kind of lifeline.
They told VOFF they could still make a submission.
Right. Not the 36 individual ones, but one single consolidated submission. They basically said, take all your stories and distill them into a policy document for us.
And VOFF did it. They submitted that consolidated version on February 26th, and the committee acknowledged they were considering it.
Which is interesting, isn't it? It shows they did want the input, but only in a format that fit their very rigid structure. The committee, by the way, has to report its findings by the last sitting day of June 2024.
But hold on, that brings up a puzzle. If their hands were so tied by the rules, why even offer the consolidation? Was it a genuine attempt to get their perspective, or was it just optics.
That is the million-dollar question. Were they trying to manage the optics of rejecting victims outright? VOFF certainly had their own opinion on that.
And this is where it really escalates from a procedural disagreement to something much more serious.
Absolutely, because VOFF did not buy the committee's reasoning at all.
They came back and said, "We strongly disagree." They argued their submissions were never about resolving individual disputes. They were about showing systemic failure at ASIC, which was part of the terms of reference.
And then they dropped the biggest charge of all, inconsistency.
This is the real bombshell. They claimed that other submissions, which the committee did accept,
And even cited in their final report.
raised the exact same issues that VOFF had raised.
Yeah. And if that's true, it just blows the committee's whole rationale out of the water, doesn't
It
it?
completely undermines it. It's
Yeah.
no longer about a misunderstanding of the rules. It starts to look like a biased or, an arbitrary decision.
And you can feel the frustration in their response. VOFF called the whole thing profoundly disheartening. They felt it was an obstruction of the truth.
They made a really powerful point about how institutions behave. They suggested that maybe their complaints were rejected simply because they, quote, expose regulatory failure.
Or just made a government agency look bad.
Right, that the real reason for rejection wasn't procedure, but protecting the reputation of ASIC.
Which gets to their core demand. VOFF argues that these inquiries have a democratic, even an ethical duty to be honest and impartial, especially with victims who've already been through so much trauma.
It's like the process itself can re-traumatize people if it's not handled with care.
I think that's exactly their point.
Mm-hmm.
And it leads to their suggestion for how this could have been handled better.
Which seems so reasonable, really. VOFF asked if the problem was that our 36 submissions were too complex, why not just talk to us?
Yeah. Why not engage? Say, look, this is great stuff, but for our purposes, could you focus on these 3 themes?
Instead of a blanket rejection, it's like asking for a bit of customer service, but for a democratic process.
And they argue this has much bigger implications. When you treat victims' evidence in this dismissive way, it erodes public trust in the whole system.
Why would anyone bother to contribute to an inquiry if they think their evidence will just be thrown out if it's inconvenient?
You wouldn't. And that's VOFF's final forceful demand. They're calling on the Senate and the government to be transparent.
To treat all victim submissions seriously, no matter how long or sensitive they are.
And crucially, they're saying allegations of, maladministration and how these submissions are handled can't just be swept under the rug to protect an institution's reputation.
So when you pull back, this deep dive really shows us this incredible tension. You have the Senate committee stuck with its procedural limits. It can only recommend policy. It can't be a judge.
And on the other side, you have VOFF arguing for a moral duty, a duty to give a full hearing to victims, especially when their stories point to massive regulatory failure.
What this really highlights is that the fight over what's considered an extraneous issue is, well, it's everything. That's the battleground.
It is. It shows that how we gather evidence can be just as controversial as the findings themselves, especially when you have these rigid rules meeting raw, emotional testimony about a system that failed people.
It's a huge challenge. How do you design a system that satisfies the legal need for a focused inquiry, but also the human need for victims to be heard?
I don't think anyone has the perfect answer to that.
It definitely leaves you with a lot to think about. And here's a final thought for you to chew on. If a Senate committee's role is strictly limited to making policy, should their rules maybe require something else? A separate, transparent process for just acknowledging the stories.
Like a public annex or something.
Yeah.
A record of systemic failures raised in submissions.
Exactly. Even if the committee itself can't resolve those specific cases, maybe there's a way to formally log them to make sure those voices aren't lost in the procedural shuffle. It's a real question of balance between what's efficient for government and what's just for the people it's supposed to serve.